plaintiff in that regard involved circumstances where there was a close relationship and there was an actual witnessing of the accident. And that's not what we have here. There was one outlier case that was referred to, and that's the Stahl versus Nugent case. That was a law division opinion where the plaintiff and the fiance were engaged at the time of the accident, but shortly after the accident became married, certainly before the running of the statute of limitations. And in that instance, the law division allowed for the presentation of a per quad claim running from the date of the marriage forward. Again, not something that we have here. The statute of limitations has expired. The status of Ms. Palumbo presumptively remains now as it had been at the time of the accident, fiance. In later decided cases, and a particular moment was a federal court case in Schroeder, which spoke to a later decided New Jersey case called Sykes, later decided meaning after the Stahl case, which indicated that the New Jersey Supreme Court, at least in the estimation of the federal court, if called upon to decide this issue, would uphold what has been the longstanding law in New Jersey, in that a per quad claim, distinct from a bystander or portee claim, only arises in the event that there is a marital union between the parties.
Counsel?
Well, thank you very much, Your Honor. Obviously, I'll rely heavily on my papers, but I will say that the first thing of note is that defense counsel relied upon the Dunphy opinion as a Supreme Court authority and went with their dissent, not with their majority. And the majority actually supports the plaintiff's position for the reasons that I've advanced in my papers. I think that that's point number one with respects to the authority of Dunphy, a Supreme Court case from 1994. Stahl versus Nugent is a law division opinion that clearly supports the plaintiff's position. The reference to Sykes, they're both law division opinions. The court can do what they wish with it, but ultimately they are both there, and that law exists and those opinions exist. And, you know, we also cited, for which there's no answer, the Bullock opinion, in 1980 opinion, in which the District Court of New Jersey spoke about legal marriage not being an essential element of the consortium claim. We cited all the social trend data, and because it's important to understand the context we respectfully submit in which we're looking at here. We have case law that specifically goes back from our Supreme Court, speaking about in 1994 with Dunphy, and the District Court back in 1980, talking about the rights of unmarried cohabitants and speaking about what those criteria would look like and what it would be. And here we have that. We have an engaged couple at the time of the accident. And the argument effectively is that let's disavow any of that case law and let's just say that reasoning somehow isn't logical and the courts never had it right with how they looked at it. But we want to act like 2020 is 1820 and act as if there's no rights here for these folks. And we respectfully submit that there is. And the reasoning behind it, when you look at Dunphy and you say, well, why would a negligent infliction of emotional distress claim for bystander liability in a personal injury case, in a motor vehicle accident case, why would we restrict ourselves to say, you can be a cohabitant here and unmarried and you can recover, but you can't in this case? The logic respectfully doesn't hold. I think the logic is that it's not the nature of an NIED or a negligent infliction of emotional distress claim. It's the nature of looking at that logic and saying that makes perfect sense when you apply it here. And if I think respectfully, if Dunphy was called upon, that Supreme Court was called upon to make a ruling in this matter, without trying to be Nostradamus, I think that the same logic that they employed there would clearly carry the day here, because ultimately I think the court has to reason and say, what's the material difference here in this fact pattern? In this case, a motor vehicle accident in which he's on a motorcycle, he gets hurt, she's living with him and they're engaged to be married. What's the difference there versus the bystander liability when we're saying that you don't have to be married in order to suffer a loss? She suffered a loss the same way. And that ultimately, Your Honor, is the heavy part of where we're going in our analysis. When we speak to Dunphy, when we speak to Stahl, when we speak to Bullock, when we speak to those cases that we've cited, and we respectfully point out that the defense's argument about citing Dunphy, they cited the dissent. And when they cited the dissent and they said the dissent says this, well, the dissent really didn't say that. The dissent quoted a 3-sentence line or so from Leonardis, I believe it was, Leonardis, the 1982 Appellate Division opinion. And so for all those reasons, Your Honor, we respectfully submit that the motion for summary judgment be denied and that she be permitted to pursue her per quad claim for the reasons that we've discussed. I would also just state that in closing, I also did address the, at the very tail end of my brief, the position that if the court were to disagree with me and the court were to say, no, I'm granting it, while we oppose it, obviously, we would simply point out that we believe it to be very important that the order would state that it would be a dismissal as to her claims as a fiance, because we don't believe that any tolling would actually apply, or we believe tolling would apply referable to her having a per quad claim in the event that there was a marriage and that it is not yet triggered under the case law that we would be arguing. And again, I know that's a secondary argument, but I believe it to be important as well, sir.
What about the Leonardis case? I know you dealt with it in your brief.
Yeah. I mean, yeah, we dealt with it, and we recognize what that 1982 opinion says, and we recognize the blip that's being quoted chapter and verse. It exists. I certainly don't act as if it doesn't, but I also can't help but recognize 12 years later our Supreme Court, and if we're going to talk about the level ups here, the Supreme Court made clear what I think is stunningly the opposite of what Leonardis was getting to, and I think that that's really more a reflection of social values, social mores, and recognition of the fact that the Supreme Court said, let's take a look at 1994, and let's take a look at the fact that people who are not officially married can suffer the same harms and losses, and this is not going to somehow lessen the burden or the foreseeability of a tort for a defendant. It's not going to negatively affect auto insurance premiums. I mean, they did cover and tackle a number of those issues, and I believe somewhere in my brief, I talked about it in my footnotes. I think it was footnote number 1 or 2. Forgive me, I don't remember offhand. But I rely heavily on the majority's logic of Dunphy, plus the other cases I cited in response to the existence of Leonardis, which we recognize as well.
Okay, counsel, I'll give you an opportunity to respond.
Thank you. And it is an interesting issue, but the distinguishing factor is that in the cases cited to by the plaintiff in support of the argument, all of those have to deal with an injury actually sustained by the fiance, the negligent infliction of emotional distress. And I think what the court recognized was that the closeness of the relationship didn't necessarily have to be a marital union in order to predicate the visiting of emotional distress on somebody. This is something different. This is a per quad claim. This is a derivative claim. And as pointed to by the Schroeder court, the sentiment and the logic has always been, this is something that you're not necessarily visiting on yourself. You're choosing to marry, in essence, a cause of action. And to the extent that the plaintiff argues that this would not be a recasting of sensibilities as it would impact what would need to be looked at in terms of future prejudice of the defendant, the court need only look no further than the argument that the plaintiff is making here, that in some sense, her ability to preserve some type of claim in the event that she's married at a later point in time be preserved. Firstly, we speak to that in our brief. The court is only really able to deal with the claims presented before it now, and that is a derivative claim for a loss of consortium based upon a fiancé status. To the extent that the plaintiff believes, at least Ms. Palumbo, that some later marriage is going to give rise to her ability to bring the claim, then she needs to bring it at that point in time. Because to have the case exist as it does now, it would certainly support an argument that if it's an independent right of Ms. Palumbo or anybody else standing in the same shoes as Ms. Palumbo, you could have that claim brought any point in time. Somebody could get married 10 years after the fact and say, I was a fiance at the time of the accident. I've gotten married 10 years later. I have, damaged goods. What would prevent somebody from doing that under the same rubric that's being offered by the plaintiff to support a claim that doesn't exist based upon a potential future marriage?
So are you saying that seems that you're agreeing with him to some extent that it's based on the current status as a fiancé, the motion itself, and either the granting or the denial is based on that.
Yeah, I mean, I don't think either of us could legitimately argue otherwise. That's what they are, or at least accepting for the purposes of that the argument, that's what they are.
Okay. All right. I appreciate counsel. This is my first virtual courtroom.
This worked out well.
Yes.
Oral arguments when I'm doing a written decision, it should work out fine. But the hearings, that's going to be another thing. Self-represented litigants, showing exhibits, that sort of thing. That's going to present some challenges, but we'll have to deal with it. So it's going to be the first of many, unfortunately. But all right, so I'll try to get that out to you as soon as possible. So I don't know when it'll be. It probably won't be today, but we have limited court staff as well. So
Understood.
we're working through this. But as soon as we can get it in up on e-courts, we will.
Thank you. Be
All right.
well, everyone.
You too. Thank you, Your Honor. Take care.